Welcome to our presentation covering downsizing and post-termination issues. Let's begin. Our primary topics are going to be the downsizing process, and then the second topic is going to be post-termination issues. Under our first topic, the downsizing topic, we're going to briefly discuss labor laws, the WARN Act, the ADEA, and particularly the Older Workers Benefit Protection Act portion of the ADEA, and the possibility or the circumstance in which the employer is in bankruptcy. Under the post-termination issues, we're going to consider the topic of unemployment benefits and how restrictive covenants, including non-compete agreements and non-solicitation agreements, interact when the employment status ends. So let's begin with those topics. Downsizing. Downsizing isn't a legal term. It's a term kind of in our culture. Another term that's commonly used for that is a reduction in force or a RIF. Sometimes the term layoff is used instead. They're all synonyms. They mean approximately the same thing. If you don't have these two terms in your Quizlet, I would recommend you go ahead and add them. This is to terminations, in other words, dismissals, that occur due to employers' judgments that the number of employees, positions, or facilities should be lower. So the employer is reducing its number of employees, and obviously that involves involuntarily separating some of those employees. Now, obviously, an employer is typically looking at reducing the employees that are the least strong performers or have the least valuable skills. So there is some judgment or some evaluation of, we're going to let go of Bob instead of Bill, but there isn't this suggestion that Bob has done anything wrong. So it's not, we're not talking about anything relating to just cause at this point. In the past, we talked about just cause in the individual employment situation, but that really doesn't have applicability here. Even facilities that are unionized have reductions in force where there's the need to reduce the staffing. And the mechanism that is going to be used to enact that reduction in force oftentimes is dictated by the terms of the contract. And in many cases, that's going to be based upon seniority. Sometimes, even in non-union organizations, seniority is the controlling way that reductions in force are decided. So the longer that I've been with a company means that I have more security. Let's imagine I've been with my company for 10 years and Bob has been with the company for 4 years. But Bob has a stronger skill set than I am and a stronger work performance history than I do, at least in recent times. So if we are in a union facility in which there's a union contract that establishes how reductions in force are going to occur, it's very likely that I will retain my job and Bob will be subject to the reduction in force. If we aren't in a union facility, then it's going to be left to the employer how to decide that. Probably in most cases, most employers focus upon performance evaluations in making that decision. Seniority, especially when people have at least a year of experience already, are not usually given as much rate as job performance. Again, this can vary. Certainly there are employers who do give more weight to seniority. Let's go to our next slide. So we're going to look at this from the perspective of the National Labor Relations Act. So this, of course, means that we're looking at situations in which the workforce is unionized. We've already looked at the term unfair labor practice or ULP before, but this is when either the employer or the union engages in an activity that is prohibited under the NLRA. In this case, as we're talking about downsizing, it would be the employer who's engaged in the unfair labor practice. If the downsizing is intended to interfere with the employee's rights under the NLRA, or the employer uses it to discriminate against certain employees because of their union activity, that would be a ULP. Let me give you a couple of examples. Let's imagine there's a union campaign in a particular facility. It hasn't been voted in yet, we'll say, for example, but there is an active effort to unionize the facility. Well, the employer might decide, we'll just close that facility down, not because it's unprofitable, but simply because they don't want to have to deal with the union. And so they might transfer whatever work is being done in that facility to other facilities. If the reason for the closing down is that the employer wanted to avoid unionization, then that would be a ULP. Of course, if the employer is simply closing the facility because it's unprofitable, then that is not a ULP. Very likely in that situation, the union will file a ULP charge, and then that board agent will investigate it, reach a decision. And if the board agent believes that it was a ULP, then there will be a hearing about it. If it just so happens that the decision to close the facility happened to coincide with an active union campaign, that certainly is likely to be perceived of as a suspicious fact. But the employer may be able to prove that the plans to close this facility had been ongoing before the union campaign started. In fact, it might be the case that the union campaign started in part because the employees were concerned that the facility might be closing. So it's certainly possible that the two incidents are not legally connected to each other. Another way that you can have a ULP would be if when the employer who is decided to do a layoff, and maybe the layoff decision is perfectly legitimate, but it singles out pro-union employees to be subject to the reduction in force. Somehow or another, it sets up the mechanism in such a way that makes it more likely that those folks will actually lose their positions. Perhaps, obviously, if there's a union contract in effect, that's more difficult for the employer to do, but perhaps the union contract hasn't been negotiated yet, or perhaps even the union hasn't been voted in yet. So if the employer starts singling out workers for a reduction in force because they are pro-union, that would be a ULP. Now keep in mind, until there's a union contract, the company would not be required to follow a seniority system in doing its reductions in force. It just can't discriminate against pro-union employees or against African Americans or Asians or Hispanics or women or men or any other protected category as it makes its decisions about employment. Downsizing is usually a mandatory topic of bargaining, meaning that a party can't avoid that topic simply by saying they would prefer not to negotiate over that. You may recall we have permissive topics, bargaining topics, and mandatory bargaining topics. So if either the union or the employer refuses to bargain about a mandatory topic, such as downsizing, and you notice there's a word might here. The law isn't 100% clear on this, but I think it's likely that it is a mandatory subject of bargaining, or would be held to be a mandatory subject of bargaining. Anyway, in that situation, the union or the employer would be guilty of not bargaining in good faith under those circumstances. As we've noted before, employers can leave a business or leave a particular geographic area. They are the owners of the business, and so they get to make those decisions even if the facility is unionized. What the employer cannot lawfully do is use their plans to close the union for the purpose of inhibiting unionization, perhaps of their remaining facilities. For example, let's say they have 10 facilities, only one is unionized. If they're closing the one unionized facility because they want to cause the other 9 to think to themselves, wow, we better not vote for unions because we see what happens when facilities unionize, they get closed. On the other hand, if an employer can show that that one unit that was unionized was also least profitable or had outdated equipment or something along those lines, in other words, the motivation for closing the facility wasn't having anything to do with the union activity, then they would not be guilty of a ULP. Let's assume that an employer sells either its entire business or a particular part of its business. That successor in interest has to bargain with the union that was in place in that facility. It doesn't have to follow the union contract, though, that the previous employer had. So that successor employer would have to bargain in good faith, but the terms may be very different, or they could be the same as existed under the previous contract. So again, the labor laws probably aren't tremendously important to us in the state of Texas, but if you're in a different part of the country, they may have increased importance. Probably the most obvious statute, though, for us to talk about in this area is the WARN Act, because this is a law that literally is about people being laid off. It's the Worker Adjustment and Retraining Notification Act. And again, it stands for WARN, and the idea behind it, the act is actually in the name. This involves the employer warning its employees that there's going to be a layoff. This is a law back, you don't need to know the year for this, for the purpose of this, but it's back to 1989. So this is a relatively recent law, much after the Title VII and the Age Discrimination Employment Act and the Equal Pay Act, just a little bit before the Americans with Disabilities Act, which was 1990. So again, the name of it is the Worker Adjustment and Retraining Notification Act. And I don't really have a definition provided here. Basically, this law, I guess maybe you could use this definition right here. Employers covered by the WARN Act must not order plant closings or mass layoffs until the end of a 60-day period that follows written notice to affected employees or union representatives and to state and local governments. Please disregard this link. It doesn't seem to be working these days. So a key fact here is that it's a 60-day notice and that it's about the idea of a notice. This doesn't really interfere with what an employer's decision is going to be. This law doesn't tell the employer you can't do a layoff or this is how you need to structure who gets laid off or anything like that. It's simply saying before you do the layoff, you get to give people notice. And the idea here is, when you're subject to a layoff, it's pretty financially devastating to you. You ideally probably want to know about it ahead of time so you can maybe make some financial adjustments or perhaps begin the process of looking for a job. Maybe you can find a job before you're out of a job. Obviously, that's the best case scenario for that particular worker. And it's not just notice to the employee, but also to state and local officials. And the goal here is that it allows those state and local officials to assist those workers in job placement activities. Sometimes the local officials will host job fairs and will even come to the facility to help employees sign up for unemployment benefits and things along those lines. So it can be a good mechanism for helping those employees make the transition to a new employment opportunity. So again, the purpose of WARN is to give the affected employers time to adjust to the job notice. So who does WARN apply to? Well, the key number here is 100. So 100 employees. The definition is a little bit more complicated than that, but if you keep in mind, if an employer has 100 employees, that's when this law kicks in. So it does not apply to small employers. You'll notice this even requires more employees than the FMLA. The FMLA applies to workforces that have 50 employees within a 75-mile radius. You may recall Title VII, it applies at 15 employees. So this threshold is quite a bit higher. One of the challenges with the 100 though is that layoffs are kind of a moving target. Usually an employer that's failing will have a series of layoffs. And so maybe the workforce starts at 100 and 5 people are let go, and then 3 more are let go, and then 7 more are let go. And so the question can become, well, on what day? Maybe we started with 100, but that was, 100 days ago. That was the last time we had 100 workers. And so figuring out exactly how many workers at what particular time were in the workforce can become problematic in making that calculation. Sometimes the calculation will look back to previous periods of time. And it's actually a 90-day period. We'll look at that in just a second. But the 90-day period can be relevant to decide how all of that plays out. That's a pretty detailed, fact-specific look, so I'm not going to be testing you on how to make that calculation. What I want you to know for the purposes of this class is the 100. And also to know that it can be complicated to calculate this. You can't just say, okay, today on Tuesday, November 4th, we had 97 employees, so therefore we don't have anything to worry about. Now, obviously, if you've never had 100 employees, you're fine. You don't have to worry about WARN Act. If you have over 100 employees today, especially if they're all full-time, then you definitely do have to worry about potential WARN Act compliance. But many times the business may fall in between those areas, and just know that it's going to require some work to figure out exactly if this employer is covered and for which particular layoffs this employer might be covered for. It is possible that there may be multiple notifications. It may be that initially one department is reduced in force and then that doesn't do enough for the business, and so another department has to be reduced in force. Or it could be a particular department is hit twice with layoffs. And so it's not just kind of one and done. You've given a WARN Act notice, you never have to worry about it again. No, you may be giving a different WARN Act notice every week or every month for a while as the business suffers whatever the collapse that might exist. So let's consider two categories for the WARN Act. The first is a planned closing, and this name is pretty intuitive. Obviously here, a plant we're using in the meaning of a unit or a facility, an office or a store. It's a permanent or temporary shutdown of a single employment site when that shutdown results in employment loss during any 30-day period of at least 50 full-time employees. So let's say you have 100 employees in let's say you're a facility that has three plants, 3 units. Now, one facility has 30, one facility has 30, and one facility has 40. So total you have 100 workers. Well, actually, let's make it 40. So we have 110. So we're not even close to the line. And let's say we decide to close this facility. Well, we meet the threshold of having 100 workers, right? So we are an eligible employer. But for a plant closing, we haven't lost 50 full-time workers. We only lost 30. So it is not necessary that we do a WARN Act notice. Now, just because it's not necessary that we do a WARN Act notice doesn't mean it's not a good idea to tell our workers as soon as we can. That's the compassionate thing to do. It just means that it's not going to be a WARN Act notice. It's going to be just notification of employees. Let's consider the other situation, and this is a mass layoff. And again, let's look at the definition here. Please consider adding this to your Quizlet. This is a reduction in force not caused by a plant closing. So again, these are two mutually exclusive categories, but results in employment loss at a single facility during a 30-day period of at least 500 full-time employees. Well, since we only have 110 total, this definition doesn't apply to us. But there's a second definition that may be more applicable to the smaller employers. So let's see this. Or at least 50 full-time employees when these employees comprise at least 33% of total employment at the work site. Okay, well, again, this doesn't capture us either because we only lost 30 workers. But let's consider a different scenario. Let's say that we have 2 facilities, one with 60 workers and one with 50 workers. And we have decided to lay off 50 of these, we'll say 50 of these workers. So this facility will go down to 10 and we'll have a total of 60 workers then at that time. Okay, well, we know it's not a plant closing because it's not a permanent shutdown of a single employment facility. There's still 10 workers there. So we know it's not a plant closing. Is it a mass layoff? Well, we know 500 full-time employees did not lose their work. But let's look at this category. At least 50 full-time employees. Well, we do have 50 here. When these employees comprise at least 33% of the total employment of the work site. Well, obviously, this is 5/6 of the work site, 50/60 of the work site. That's well above 33%. So in this scenario here, we do in fact have a mass layoff. So again, it can be a kind of a tricky formulation to go through all of these particular situations. Now let's consider a few limited circumstances when an employer's failure to give the legally required 60-day notice may be legally excused. And this is typically when there's something outside of an employer's control that is unexpected. For example, a natural disaster, a hurricane hits your facility, or there's a fire or a flood or a tornado, something along those lines. A pandemic, certainly. Let's say you run a chain of restaurants and the governor closes all the restaurants for a period of time. That would not, you would obviously not have to do a Warrant Act notice under those circumstances. But it's not just things that are kind of these global catastrophe type situations. They can be things like this. Let's say that you happen to have one big customer who maybe comprises 30% of your orders, and that customer goes bankrupt, goes out of business, or chooses to take its business elsewhere and didn't give you advance notice, and suddenly one day you had this business and the next day you just don't have this business anymore. And as soon as you know about it, then you have to give notice, but you may have to do the layoffs faster than 60 days because that business is gone. And so sometimes it can be a very localized issue for a particular employer, not kind of that global bad weather or pandemic or something along those lines. Let's consider this case. Does an employer have a warrant obligation if a mass layoff occurs over multiple non-contiguous employment sites? Let's go here and let's review what a mass layoff is. A mass layoff is a reduction in force not caused by a plant closing, but that results in employment loss at a single work site during any 30-day period for at least 500 full-time employees. So it looks like from our definition that the answer here would be no, right? Well, let's look at the facts of this situation. So in 92, there was a layoff affecting 500 employees. The employer did provide the 60 days notice, but the employer also laid off 27 workers at several different locations, and the employer did not include those 27 workers in the 60-day notice or give them the 60-day notice. And these workers said, hey, we should have been rolled into this 500 group who did get the Warrant Act notice. And the Court of Appeals said, I guess this is the Fifth Court of Appeals, yes, Fifth, because it rose out of Houston, held that no Warrant Act notice was necessary for employees at locations where mass layoffs did not occur. Again, these 27 workers were not in the same facility where the 500 workers were located. Let's consider what needs to be in that Warrant Act notice. So the name and address of the employment site has to be listed. The official who can provide further information has to be given. Again, this is especially helpful when the notice is given to the state and local officials so that they can contact somebody to say, hey, we'd like to do a job fair, or we'd like to come in and help people do their unemployment. The statement has to say whether the action will be permanent or temporary. Again, that helps the employees know, whether this is the end or whether there might be a chance to come back. And the statement needs to be whether the entire facility is closing or just a portion of it. Then there needs to be a list of all of the employees who are affected. So we need their names, their titles. That information has to be provided as part of that notice. Okay, now let's consider, what happens though, I don't have a slide for this one, but let's talk about this briefly. Let's say that an employer doesn't comply with it. The employer only gives 40 days notice instead of the 60, and the employer doesn't have a legal excuse. Well, what happens to the employer? What the employer is going to have to do is pay those workers for those 20 days on an unpaid basis. And so it doesn't mean that the employer doesn't have to pay just because he wasn't good about giving the notice. He will have to pay just as if he had given the 60 days notice. And again, these issues can be confusing because many times there are disputes about whether the employer was covered by the statute, whether it really was a plant closing or mass layoff, or whether there was a legal excuse. But if all of those are found to be covered by the Warrant Act, then the employer is going to need to pay the folks out through the 60 days. So if they got, 35 days notice, then they'll have to be paid 25 days, for example. Let's discuss the next topic, which is the Age Discrimination Employment Act and the Older Workers Benefit Protection Act. The Older Workers Benefit Protection Act is an amendment to the ADEA. You may recall the ADEA was passed in 1967. I'm not sure when the Older Workers Benefit Protection Act was passed, either the late 80s or the 90s, but quite a bit after. And this statute did several things, but for our purposes, one of the big things it did was it put certain requirements in waivers that have to be present in order for the waiver to release any claims under the Age Discrimination Employment Act. Okay, so the usual rule about selecting employees for a downsizing is you can't discriminate. You can't discriminate against union activity. You can't discriminate against any of the Title VII protected categories such as race, religion, color, national origin, sex, and now sexual orientation and gender identity. You can't discriminate based upon age, and you can't discriminate based upon a disability status. So you can't select people on that basis. But it's not just whether you can't discriminate under a disparate treatment category. It also can't be a disparate impact situation. So just a little refresher, disparate treatment is when I decide either consciously or unconsciously, I don't like Bob because he's a Hindu, or I don't like Bob because he's an atheist, or I don't like Bob because he's African American. And that's why I'm laying him off. I'm discriminating against him directly because of his protected category. Disparate impact is when I have a neutral qualification that tends to unequally impact a certain group. For example, if I were to use dates of hire, and so I laid off the most recent hired folks. Well, let's say that my particular facility had a long history of discrimination against African Americans, and it was only in recent years that African Americans were hired in numbers reflecting their presence in the population. Well, because they, through no fault of their own, don't have the length of seniority that the Caucasian employees have, then in this reduction of force, the African Americans would be disparately impacted if we were to look at seniority as the basis for a reduction in force. So again, you can have disparate impact in play as well as disparate treatment. Sometimes it can be tricky to decide whether a particular person was affected by a reduction in force or for some other reason. For example, if we're in the middle of a reduction in force in a particular facility, but the whole facility isn't closing, and let's say that I was experiencing performance issues. Well, the employer might say, well, we're going to go ahead and fire you for your performance issues. And let's say the facility had, or my department had 100 workers, and the employer already decided that they needed to get rid of 20, so they needed to get down to 80. And while they're in the process of sorting through which 20 to get rid of, they decide to get rid of me because of my weak performance, or what they say is my weak performance. And so now they only have to get rid of 19. So in some sense, I'm part of that 20, because as soon as they let me go, well, they don't need to let go 20 more. They only need to let go of 19 now. And so there's a reasonable issue about whether I'm part of the reduction in force or not. As a general rule, a person is considered not part of the reduction in force if another employee goes in and takes his job. But there can be almost like I don't know what the term for it is, but a domino effect. You might have people who can, I can't remember the term that is used for it, but they can take another person's job. So let's say we have Bob up here. So Bob is in an department. He has a lot of seniority, but a lot of the people in his department have a lot of seniority. And so even though he has we'll say 20 years of experience, he's a relatively new hire for his particular department. And so his department is, we'll say, eliminated or significantly reduced in numbers. So he may be able to take the job of someone else who has less seniority that he is qualified to take. I can't remember, there's a particular term for that, so I'm just drawing a blank here right now. So in that situation, Bob doesn't get laid off. I mean, he's dropped to a lower level, but he takes Larry's job because Larry only has 15 years of experience. Then Larry takes Susan's job. Susan only has 10 years of experience. Susan leapfrogs into Mary's job. Mary has just 5 years of experience. And Mary leapfrogs into Jane's job. Jane only has 1 year of experience. So Jane is the only one who loses a job. And Jane has no connection to Bob's department up here, but it's just this kind of domino effect that has that happen. So we would definitely say that Jane was subject to the reduction of force, even though Mary took her job. So when I say this can be kind of a confusing statement. It's true, but it's not true if we're doing this kind of domino effect. In this kind of situation where there's a domino effect, Jane certainly is subject to the reduction of force. A genuine reduction of force means that someone else is assigned to do the employee's work, or the work is distributed among other existing employees already performing related work. So I think, and one way to look about this is that this is another worker, perhaps another worker outside of the facility. If it's a homegrown worker who is dominoing into the particular job, then that certainly can be a reduction of force. Now, some employers don't like to do this domino effect. Many times union contracts require it. The concern is that if, let's say Bob's department was completely eliminated. If you just say, Bob, we don't have a job for you, then you've really only ticked off Bob. But in a way, not to be mean about it, but in a way, you know, Bob's no longer here. You don't really care too much if you've ticked him off. But if you say, Bob, you still have a job, you're good, but it's not the job you want. You're going to have to go down to Larry's job. And then we say to Larry, you're going to go down to Susan's job. And then Susan's going to take Mary's job. Mary's going to take Jane's job. And Jane is out of a job. Well, again, we don't really care about Jane. She's no longer there. But we now have 4 people who are not too thrilled. They're all doing a job that isn't the job they wanted to do. And they're probably earning less money. And so what you've done is by having this kind of domino effect, is you've antagonized 4 of your workers. So it can have a powerfully negative morale impact under those circumstances. As we've talked about before in talking about performance appraisals, performance evaluation systems are a very common way to do reductions in force. Also, seniority is a mechanism. Sometimes both of those are used in some system together. Obviously, whether you use seniority or performance evaluations or some other system, you need to make sure that it is not discriminatory. And really, age discrimination claims are some of the most dangerous in this area. I talked more about that in a previous module and how that can be a specialist in this case, so I'm not going to talk about it here. But it is a good idea to do some statistical analysis of that. And you need to be fairly granular. Don't just pick everybody over 40, because you may find that your 40 to 45 population isn't really being discriminated. There isn't a disparate impact upon that population. But maybe in your over 50 population, there is a disparate impact. So you need to kind of decide how granular to get. Maybe you have the population broken up into 5-year segments or something along those lines. An age discrimination plaintiff must show that the employer treated them less favorably than employees who are substantially younger. But it's not necessary that those employees are younger than 40. Usually about 5 to 7 years is what we mean by substantially younger. Let's see here. And this is just a summary about 2 ways of looking at the prima facie case. This one is really focused upon the prima facie case in a RIF situation. So again, because we're looking at an age claim, the worker is going to have to be 40 or older. He has to fit into that protected category. Remember, that's always our first RIF requirement. He or she was selected from a larger group of candidates for termination from a larger group of candidates. he or she was performing substantially equivalent to the lowest level among the group of employees retained. So this is really about qualified right here. This is the equivalent of qualified. And this means that there was an adverse action here. And this is the additional, the plus that you need. The group of employees retained included one or more substantially younger employees who were not performing any better than the terminated employee. So you see the same 4 factors that we've seen again and again in the reduction in force. This one is a little bit less focused upon RIF, but this is a helpful mechanism too. Again, we need to prove that the person is in the protected category. He was performing his job under reasonable expectations. He was terminated. So this is again that qualification thing. He was terminated. That's the adverse action. Other similarly situated employees were treated more favorably, or there's some other piece of evidence. So this is that extra piece that is necessary. Now again, whenever we're talking about prima facie case, that's the first job the employee has, but then of course the ball bounces to the employer, right? And so the employer must articulate the lawful reason for selecting the employee for termination. So just because a prima facie case has been made, it doesn't mean that the game is over, by no means. In fact, that's just the first act, if even the first act. That's almost the prologue to a lawsuit. So now the case starts being about, well, what is the employer's reason? And is that the true reason? And if it is the true reason, is it non-age discrimination? And then of course, once the employer presents that, then the ball goes back to the employee, and the employee has to show that the employer's stated reason was pretext, and that again, the true reason was age discrimination. So proving pretext in and of itself isn't enough. The plaintiff also has to show that the real reason was age discrimination. The burden of proof always remains with the plaintiff in these cases. Okay, this isn't so much of a definition. We've already had a definition, I'm sure, in several other slides for the ADEA, but this is a good thing to remember, that the ADEA prohibits mandatory retirement except for certain persons in bona fide executive and high policy-making positions. So you can't have that age 65 automatic retirement except in very unusual circumstances. There are also some exceptions for safety-sensitive jobs like police officers and firefighters, and jobs that really require a high level of physicality and involve some level of danger. Also, well, we won't focus on that one. That's a little bit specialized. Of course, if an employer wants to have an age 65 retirement age for some really senior executives, that can be an option. In my experience, employers usually do not like to use that option. So the bottom line is, employers can enforce employees to retire at a certain age, and employers shouldn't assume that an employee is going to retire at a certain age and make decisions. Oh, well, Bob is 63, he's probably going to retire in a couple of years, so he probably isn't interested in promotion opportunities. Well, no, actually, you can't make that assumption. That's a type of age discrimination. This one really isn't a definition either. We've had other definitions, the Older Workers Benefit Protection Act. This is talking about one particular feature of the Older Workers Benefit Protection Act. It is true that it is legal under the Older Workers Benefit Protection Act for employers to offer early retirement incentives. Even though younger employees, even younger employees who are over 40 may be excluded. You can't exclude older workers. You can't have a window, say, people 50 to 55 are eligible for this package. You can't exclude the 56-year-olds, but you can exclude the 49-year-olds if you want to. Even though the 49-year-olds are over 40, you can exclude younger. Any type of early retirement incentive or voluntary retirement programs has to truly be voluntary. Another thing that's important to keep in mind here is that they have to, if an employer is considering offering an early retirement plan, let's say Bob is 51 and he decides to retire. He tells the employer, we'll say on November 1st, that he's going to retire. Well, let's say that the employer started thinking about an early retirement plan on September 1st. and it decides and announces it on December 1st. And as part of that plan, anyone over 50 is eligible. Well, in that situation, Bob had no idea this was about to be rolled out. But because it was being considered on November 1st, because obviously we started on September 1st, then Bob would be retroactively eligible for that. Maybe he's already left the employee of the company by December 1st. Maybe he just gave 2 weeks notice, but he would be eligible retroactively for whatever the benefits were under that program. And let's consider bankruptcy. This is, we're talking about the employer's bankruptcy. So what happens when a company goes bankrupt in terms of the employees? Well, as you can imagine, there are wages to be paid. The employees want to get paid their wages. Well, this is not a bankruptcy course, but is just a very brief summary, a little bit about about bankruptcy laws. As a general rule, there are 2 categories of creditors. And again, a creditor is somebody who is like a bank who you owe money to. So you've got lenders and you've got creditors. And in some sense, employees are creditors. If I work for you for 10 hours and you haven't paid me for those 10 hours, and let's say you're paying me $12 an hour, you owe me $120. So you are my you are my debtor, and I am your creditor. Well, if you file for bankruptcy before you pay me, I am not a secured creditor in that situation. So what do I mean by secured creditor? Secured creditor is somebody who is entitled to some type of asset if the payment is not made. So for example, let's say I buy a house, and the house I buy it for is $300,000. I put down $100,000. So I get a loan from the bank for $200,000. But when I sign that document with the bank is going to insist that if I default on my loan, that the bank is going to be able to sell my house, the house that I'm buying, and get its $200 out when it sells my house to somebody else. So my house is the collateral, is the security for that loan. So in that situation, the bank is a secured creditor. But again, when I am a worker for my company, I'm not a secured creditor because I don't have an asset that I'm entitled to grab in the event that my employer doesn't pay me my wages. So I am not a secured creditor. I'm not at the very front of the line to get my stuff, but I'm close to the front of the line. I'm behind the secured creditors. I have relatively high priority. I'm more likely to be paid than many other people who are entities that may be creditors of the company. My best claims are going to be for wages and benefits that I am due, that I worked for after the bankruptcy was filed. And the idea here is that a Chapter 11 bankruptcy is not a liquidation bankruptcy. The hope is that the company is going to be reorganized and will be able to continue. And of course, if it's going to continue, it needs to have workers. It needs people who can do the stuff that needs to be done to run the business. And so usually the workers who continue to labor after the bankruptcy filing are treated more advantageously than the workers who earned money before the bankruptcy filing but haven't been paid. Now, obviously, many times those are the same people, but that person has kind of 2 categories of claims. So let's say I've worked for this company for the last 20 years. I was paid consistently, but the 2 weeks before the bankruptcy filing, I wasn't paid. And then the 2 weeks after the bankruptcy filing, I also wasn't paid. So again, the most recent 2 weeks after the bankruptcy filing, those are my best shot at getting money. Non-union employers in bankruptcy can cancel raises, bonuses, they can cut wage rates, they can reduce benefits. And again, whether I actually get the money that I am owed may or may not happen. Again, it's going to turn on how much money there is available to all the various creditors. So union employers can ask, again, the union employers in bankruptcy can and routinely do ask the union for concessions. It's going to turn on the judge's decision whether or not the judge will throw out the union contract and not require that the employer continue to comply with that contract. There's a complicated analysis that happens under those situations. If the employer, the bankrupt employer, wants to persuade the union to accept concessions, the employer is going to be required to provide lots and lots of information to the union to explain exactly how strong the company situation is, what its creditors are like, what its cash flow situation is, all of those things. And of course, the employer would be required to bargain in good faith under those circumstances. So now we've completed the downsizing issues relating to doing a large reduction in the workforce. Let's discuss the post-termination issues, specifically unemployment benefits and also restrictive covenants. So when a person has been separated from employment, it's pretty common, almost automatic for that employee to go ahead and apply for unemployment benefits. They're obviously also going to be looking for employment as well, but usually or oftentimes they are not able to immediately find employment, and so they will be eligible for getting some unemployment insurance. And the term unemployment insurance is pretty descriptive. This is designed to be a safety net for that particular employee. And in some sense, that employee has been paying for it throughout his or her employment, because the insurance is being provided by the employer as one of the benefits of employment. And so this is kind of a safety net for if something bad happens to the employee is not going to be left high and dry. He's going to receive some wage replacement until he can find suitable employment. It won't be complete wage replacement. Again, I suppose if it were complete wage replacement, it might be the case that the particular employer, the employee might be less motivated to find employment of some type. So, but it's, it varies from state to state, but usually it's between 2/3 and 3/4 wage replacement. But there is an upper cap. So for more highly compensated employees, it may be less than that amount. But an important standard here is going to be whether the employee engaged in misconduct. And sometimes it's relevant whether the employee voluntarily resigned. So let's look here at the website for the Texas Workforce Commission. And here is the Texas Workforce Commission's website. This is the organization that is our FEP organization, and it's also the unemployment department. And we have here, oops, I went too far. Yeah, here, fire. If the employer ended your employment but you were not laid off as defined above, then you were fired. If the employer demanded your resignation, you were fired. So again, this is resignation in lieu of dismissal. You may be eligible for benefits if you were fired for reasons other than misconduct. Examples of misconduct that could make you ineligible include violation of company policy, violation of law, neglect or mismanagement of your position, or failure to perform your job adequately if you are capable of doing so. So that gives you a little bit of granularity about that topic. In addition to you needing to have been involuntarily separated and you needing to have been involuntarily separated due to something other than misconduct, you, the worker, also has to be able and willing to accept suitable employment. So if you are disabled, for example, you aren't eligible for unemployment benefits. You may be eligible for Social Security disability benefits, but since you can't work, you can't get unemployment benefits. The equation for calculating exactly when you're eligible and how much you're eligible for in terms of pay is a rather complicated system involving looking at various quarters, kind of beyond the scope of our class. If an employee is discharged for misconduct, he or she might be denied benefits. However, it really is restricted to only serious intentional misconduct. Typically, an employee applies, and then if an employer wants to challenge the employee's eligibility, and typically the usual reason for the challenge is that it was misconduct, then the employer is going to have to prove that. the hearing referee is very likely to be inclined to award benefits. This is a situation that typically state systems are quite pro-employee, and that makes sense because this is intended to be an insurance policy for the employee, and so it shouldn't be denied except when it's clear that the employee is not eligible. You may say, well, why would employers care whether the employee gets unemployment benefits or not? Well, it's important to the employer because the number of successful claims that the employer has is going to affect the employer's experience rating, and it means that the employer is going to pay a higher unemployment insurance amount. It can be pretty significant in terms of dollars. For that reason, many smart employers choose to be very reluctant about ending employment unless they have a very clear case of misconduct. And under those circumstances, they will, put up with some maybe less than awesome work performance because they don't want their unemployment rating to go up too much. So in Texas, employees who are on strike are not eligible for unemployment benefits. That is not true in all states. Some states do allow the workers who are striking to receive unemployment benefits. And the striking workers can receive unemployment benefits if they have been permanently replaced. In other words, there's really no longer a spot for them at that employer. So in that situation, you could say that they are involuntarily separated from their place of employment and become eligible at that time. The employers should not routinely contest unemployment insurance claims, but only do so when they believe that the employee either voluntarily quit or is terminated for serious misconduct or is committing some kind of fraud on the unemployment system. And now let's consider restrictive covenants. We've talked about these in the past, so I'm not going to do a very deep dive here. Here's a little refresher of an important term, though. If you don't have this in Quizlet, please be sure to add it. Restrictive covenants are contractual agreements that aim to protect employer interests by limiting the ability of former employers to do such things as going to work for competitors, disclosing trade secrets, soliciting clients or former coworkers to do business with or join other firms, or making disparaging comments about their former employers. Now, a restrictive covenant doesn't have to have all four of these, so I'm going to say or here. Now, it could have more than one, but it doesn't have to have all four of these. It's becoming more and more common for employers to use restrictive covenants, and certain industries, especially high-tech industries or sales positions, oftentimes have restrictive covenants involved. So here's a particular type of restrictive covenant called a non-compete agreement. Sometimes they're called non-competition agreements or non-compete covenants. So those are all synonyms for the same thing. These are restricted covenants designed to prohibit former employees from working for the competitors of their former employers. The court system generally looks at these fairly suspiciously because in some sense they are creating almost a monopoly for that particular employer. If I am, let's say I'm a registered nurse and I work for a hospital. Let's say I happen to be, and I'm ignorant about healthcare, but let's say I specialize in surgical. My practice is focusing on in a surgical situation. And let's say in my community, there are only 3 places within 30 miles that require a surgical registered nurses. I'm working at one of those places and my employer requires that I sign a non-competition agreement. I sign it and then 6 months later it fires me for no good reason. But according to the terms, I am restricted out of working for either one of the other 2 because they're competitors. I then am stuck. I mean, I can probably become a registered nurse doing some other function, but maybe I was highly compensated because of my surgical skills, and I would be taking a significant pay downgrade, or it just isn't as satisfying to me, or the hours aren't as good for me as it would be if I were doing my old job. So I might be forced to relocate to another place. And so you can see how under those circumstances, once my employer requires that I sign the non-compete, I'm almost a hostage of that employer. Let's say the other two surgical theaters in my community start offering significantly higher wages for registered nurses. Well, I can't take advantage of that. My employer might actually reduce my pay because it knows that I can't go to work for them because of this non-compete. So you can see the problems that can occur when you have kind of unrestricted use of non-competitive agreements. And as a result, courts are suspicious of them and only are going to enforce them when it really is protecting a legitimate business interest. And they should be narrowly crafted, narrowly written, to be no broader than what's necessary to protect that employer's legitimate business interests. If they are overbroad, sometimes courts will throw the whole thing out. Sometimes courts will just rein it in and redraft it so it's a more reasonable level. As I've said in previous lectures, states vary widely in how they will enforce or maybe not enforce at all non-competes. California won't enforce them at all. There are some states that almost always enforce them. I like to think of Texas as being somewhere in between. So let's put California here, and lots of states are kind of over here. Texas, 20 years ago, was theoretically probably in this area. Well, let's say 30 years ago. It was theoretically in this area. Well, 20 years ago. But it was probably more like in this area. Because what courts would say is, yeah, we could imagine a non-compete that's enforceable. We've just never seen one. But it's out there. We just never seen one. But with changes, even though the law hasn't changed, the statute has been unchanged for many, many years, the composition of the Texas Supreme Court has changed. And so we've seen this slow process. And so now we're kind of in this middle area. There's lots that our Texas Supreme Court will not enforce, but there's also a lot that have been upheld. And we've really seen this change in the last 15 to 20 years. And so the law has somewhat stabilized. When I used to do this lecture 10 years ago, I would say, you know, it's still really a moving target. We don't know where it'll end up. I'd say I'm not saying it's fully, you know, every single detail, but I think we know that there's a significant number that are enforceable, but they will be examined carefully, probably more carefully than probably about half the states. I'd say we're kind of in the middle now. Texas courts require that the non-competes be reasonable with respect to these three elements: geography, time, and scope of activity. So let's examine each one of these. Actually, let me show you the statute so we can actually see the language. Here is the statute. So you can see limitations contained in the covenant as to time, geographic area, and scope of activity must be reasonable. So time, typically we'll see 2 years as being considered reasonable. This can be lower though, because if a person has trade secrets that really cease to be valuable to other employers after a year, then 2 years would be too long. There could be, for example, let's say I'm a hairstylist. My customer list after 2 years, if I'm not using it, is not going to be very valuable because people don't wait 2 years between haircuts. And so 2 years would be probably too long. On the other hand, let's say my job is I'm a tractor salesperson. Well, farmers don't buy a tractor every year or even every 2 years. They may only buy a new tractor every 10 years. And so a 2-year period of time, if I'm a tractor salesperson, is probably too little time. It could be longer than that. Geographical area is going to turn on the particular industry as well. There are certain industries that are nationwide. For example, let's say that I'm a software engineer. I write software. Well, the software that works in Texas is obviously going to work in California and Massachusetts and anywhere else, anywhere around the world. So there really isn't a geographic area that would be unreasonable in terms of scope. But again, if I'm a tractor salesperson, my customer base is not going to be in all 50 states. I may have, East Texas and Western Louisiana. And so whatever my geographic territory is probably what's going to make a reasonable set of limitations for the geographic area. The scope of activity is probably going to follow pretty much what my responsibilities were and what the information I had access to. So if I, for example, was a hairstylist, then that's probably the scope of activity I should be limited from. So if I decide to work for as a nail tech, for example, that's a different industry. If I wasn't doing nail tech work for the styling salon that I was initially working for, then I should be able to be a nail tech somewhere else. But if I was a stylist for one salon, I shouldn't be able to be a stylist for another salon if the contract provides that it would be limited. So the scope of activity is usually going to be pretty similar to what my actual job responsibilities were. In addition to the requirement that it be reasonable in geography, time, and scope of activity, it also has to be ancillary to or part of an otherwise enforceable agreement. And we have that right up here. This is where most of the case law is for making it difficult to be enforceable. I'm not going to bore you with a detailed analysis of this, but I will let you know that you should never attempt, if you go to work for a corporation that doesn't have inside counsel, you should never attempt to draft this language on your own. There are plenty of types of contracts that paralegals can be extremely involved in writing the language for the contract. And there isn't even always necessarily a concern about the unauthorized practice of law. But with respect to non-competes, you really, really have to understand the details, the minutiae of the case law. And so it shouldn't be attempted by anyone other than an attorney. And I would say not even just an attorney, but an attorney who practices in this area. It really is very, very specialized. Another type of restricted covenant is a non-solicitation group. Oops, wait a second. Hit the wrong button there. Non-solicitation agreement. It prevents former employees from soliciting the firm's clients after the employee leaves. Typically, courts are a little bit more open to these because they don't stop, assuming that, of course, the non-solicitation agreement can be bundled with a non-competition agreement. But let's say it was just a non-solicitation. This doesn't stop the employee from getting a job. It just means that employee can't, solicit certain former customers. So there's usually a little bit more leeway in this situation. Another important term in this area is trade secrets, and this is a definition for that. It refers to information that's actual or potential economic value because it's not generally known to others outside the company, and the owner makes it reasonable efforts to keep the information secret. So the owner here is the employer. Now trade secrets don't have to be subject to an actual contract between the employer and the employee. The law says that employees have, under the common law, a duty to not to disclose this information, either while they're currently employed by the employer or after the end of the employment. So that's a trade secret. And we now have covered all of our topics. We've talked about downsizing, the impact that downsizing can have on labor laws, the WARN Act. We discussed the ADEA and a little bit about the Older Workers Benefit Protection Act. Oh, by the way, one thing I don't have a slide on, which I wanted to talk about, which I'm glad I thought about it right now, is the 45 days. You may recall that it was 21 days in our previous module when it's an individual termination and we want to use a release with respect to somebody over the age of 40. But it's 45 days when it's a layoff affecting more than one person. And I said during that lecture, I'm going to stop and tell you why it's 45 days when it's a larger action. The reason for that is the Older Workers Benefit Protection Act requires that when it's not just an individual who's being subject to dismissal, but a larger category, then the employer has to give a list of all of the people who are affected and their ages. And the reason for this is that it's very hard to know whether you've got a good claim or not. Because this may be a nationwide reduction in force. And you know your own age, and you know that you were subject to the reduction in force, and you probably know a few other people who were laid off and a few people who weren't. But you don't have a statistically significant pool to draw from. So you're in a really hard position to know whether to accept the package you're being offered or to say, no, I think I could get more money if I were to sue. So for that reason, the statute, the Older Workers Benefit Protection Act, requires that each one of the workers who were subject to the reduction of force and who are over the age of 40 get this list listing everybody in all of the relevant job categories, saying whether they were reduced in force or not, and their ages. And through that mechanism, then you, the employee, can do the statistical analysis to see, yeah, gosh, it looks like a lot of people in my age category were subject to the reduction in force. I think I probably have a good age claim. I'm not going to accept this package. I'm going to go ahead and sue my former employer. Or, gosh, it looks like a lot of young people were dismissed as well. Doesn't look like I've got a very good claim. It's probably a good idea that I do accept this package. So in addition to getting more time, you get more data when it's more than one person being affected. And of course, another reason that you get the more time is so that you have the time to talk to your attorney and to analyze this data. And sometimes the data can be quite complex. It's not something you can kind of eyeball and decide. I've seen RIF packages where, you might get 10,000 people, their data listed, and you have to kind of sort through, and there'd be lots of different ways of massaging that data. You could massage it by geographic location, you could massage it by position, you can massage it by age, you can make narrow, all people who are age 57 or older, or all people who are age 57, or you could do it in 2-year, lumps, or 5-year lumps, or 10-year lumps, lots of different systems. And so just the number crunching and the statistical analysis is one of the reasons why you get, instead of 21 days, you get 45 days. Whether it's 21 or 45, though, you always get 7 days to revoke after you've exercised your rights. We also discussed bankruptcy when the employer goes bankrupt, and we discussed some post-termination issues, including unemployment insurance benefits and restrictive covenants. At this time, we're going to go over a few management tips to give to your clients as they work through the unfortunate situation that a layoff may be necessary. So typically, unless it's a very small employer or it's a very small layoff, it makes sense to engage legal counsel. It may be in-house legal counsel, or it may be a counsel that is hired from a law firm. And the counsel needs to be involved in doing statistical analysis and also evaluating the criteria that is being used for employee selection. It's important that those criteria be applied consistently. Inevitably, it's going to happen that you look at the names that are affected and you think to yourself, oh my gosh, that breaks my heart. That's such a good person, or that person's going through such a tough time. Can't we make an exception here? But you just can't. You have to be consistent with that criteria. Now, of course, you can look and see who's affected and decide, well, we aren't going to use that criteria. We're going to use some other criteria instead. But once you pick that criteria and decide this is what you're using, then you have to accept the good and the bad from that. Of course, there needs to be analysis about the disparate impact that may happen to certain groups, with special attention to older workers, but also to women and minority groups as well. It may well make sense to offer severance benefits in exchange for a waiver. It's pretty common to give some kind of package to folks. And usually those packages, when I say packages, basically I mean pay. It's usually that the person has to sign a waiver under those circumstances. Oftentimes those packages are related to the length of service that a person has gotten. It may be 1 week per year of service, or some equation like that to award the employee for their service. You want to make sure the Older Works Benefit Protection Act is being complied with. Technically, this applies to only people over the age of 40. In my experience, typically employers use a similar release whether the person is over or under 40. It just becomes a logistical nightmare to have two types of releases. And if you have two types of releases, inevitably somebody gets the wrong one. It's just cleaner to have one release for everyone. If the WARN Act applies, or there's a union campaign, or there's a union representation of facility, you need to make sure you're following the language in the employment contract or the collective bargaining agreement, and you need to give the appropriate notices under the WARN Act. And of course, whenever you're doing a layoff, you aren't going to contest unemployment benefits. I hope that this presentation, another thing too, sorry about that. If you are considering using non-competes or non-solicitations, again, you'll need to consult with an attorney who specializes in employment law to make sure that that type of agreement is appropriate. And if it's appropriate, what the scope of that can be and what that language in that agreement ought to include. So at this point, we are completed with this topic. As always, if you have questions about the material, please don't hesitate to stop into my office hours. I'll be delighted to talk to you in more detail about this information. As always, I thank you for your attention. I hope this information has been helpful, and I hope that you have a wonderful day. Take care.